And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Oh no, that song again. I don't know whether I can live through another round of it. Good morning, Happy New Year, and welcome to The Law Show for this first one of 2016. I'm Sterling Fox, and many of us are still dealing with New Year's resolutions, or at least the very best of intentions, leaning towards resolutions. And one of those resolutions, hopefully, for a lot of our listeners today, is going to be on their personal circumstances, getting around finally to having a look at the will, perhaps maybe even getting a will for the first time in your life, or maybe updating that will that you got when your first kid was born back in 1981, or perhaps just having that legal checkup. It's a good time to consider that. And with us in studio, it's a pleasure to say Happy New Year to John Lakes and John White of LakesWhyteLLP of North Vancouver. They are wills and estates litigators and lawyers. Good morning and Happy New Year, guys.
Good morning.
Good morning. Happy New Year.
Gee, what a bright bunch you are for just the third day of January. Mind you, that recovery day yesterday was important before sitting down this morning, wasn't it?
The hangover's gone.
Well, good for you. Lakes White, John Lakes, is a North Vancouver firm populated by two North Vancouver guys, one of whom is locally trained and the other of whom, we'll find out in a few moments, isn't. You're a Delbrook guy, as I recall, right?
Yeah, I went Delbrook High School.
That's right.
Same high school as Margaret Trudeau, but she's much older than me. So, and Pia Chandel, too, who you probably know well,
I've
and
worked
Karen
with Pia,
Magnuson. Sure. But anyway, so I've lived in North Van most of my life. I've been practicing in North Vancouver since 1981. I've had my own firm since 1987 and 1986, and I do primarily sisters work. I work a lot with the middle class. I do a lot of wills, estates, real estate matters, small business, and general other matters that people, ordinary North Vancouver, West Vancouver, Squamish people have to deal with.
All right, and John White, far too young to have gone to high school with Margaret Trudeau. Nonetheless, a North Shore guy who went to the University of Toronto for your law degree.
That's right. I took 3 years out from living here in Vancouver, or really living on the North Shore. Went out to Toronto, had a great time, got my law degree out there, and then immediately hopped back into the car, and by the first evening, I was already in Sudbury, so on my way back.
Well, we're going to talk about wills on the program today. So one of the things, and that legal checkup, this is John White's idea, time for a legal checkup. And, of course, when you have that in mind as we approach a new year and our list of resolutions, frankly, I'm thinking this legal checkup business a whole lot more accomplishable than losing the 15 pounds I keep promising myself I'm going to do early January every year. So, John Lakes, what is a will, and why is it so darn important?
Well, a will is a written document that has to be signed by the person who makes it with two witnesses that sets out the disposition of their assets after their death. So it's like their last message to the world after they're gone. And it's called your last will and testament because you're actually testifying to the rest of the world, this is what I want done with my assets. And it's also the last, it's the one thing that survives your death.
Right.
It's your directions after death because it doesn't come into effect until you've died. So it's one of the few things that survive death. And it's important because if you don't do a power of attorney, then under WESA, which is the Wills, Estate and Succession Act, there's a whole process which directs how your assets would pass if you die without a will, and that may not be what you want.
Right.
And in particular...
So it's your last chance to be in charge, isn't it?
That's right. And one of the big things that's significant, for example, if you're leaving monies to children under the age of 19, and if you have it under the will, you have somebody who can control the funds. However, if you died without a will, the funds are paid to the public guardian trustee, and that child would get their money on their 19th birthday, which in some cases could be a lot of money.
Right.
And in the meantime, the PGT controls the funds. They charge a fee for the funds, and they do a good job, but they're bureaucratic, and they may not be able to act as quickly as you wish. So, for example, you may the wife may be the guardian of the child, and you want some money for ski classes, and you apply in October, and you don't get a response till the end of March.
Right.
You missed another ski season.
Mm-hmm.
So that's the other important thing about the will, is you also say who's to be in charge of your affairs when you pass.
Right. And John White, and I'm glad that your partner here opened up the door to this public guardian and trustee, because I think there's a myth out there that I would appreciate your helping me burst this morning, and that is that a lot of people still hold this. I don't know where it comes from. But maybe it's the way they used to do business 50 or 100 years ago. But if you, some people to this moment believe that if you die and you don't have a will, if you haven't any instructions about what's to happen to you and your estate after you're gone, the government gets it all. Not this public guardian thing. The government gets to take it all and dispose of it as they please. People believe that. Not true, right?
Well, I almost hate to say it, because that would be the greatest motivator of all for people to get a will.
Yes.
But that is completely not true.
Okay.
I'm going to burst that balloon right now. If you do not have a will, it does not mean that all of your property goes to the government as some sort of fine or some sort of forfeit.
Right.
What it does mean is that there are rules that have been put in place by what is now the Wills, Estates and Succession Act, or WESA as we love to call it,
Right.
which will set out, in the absence of direction from you, what will happen to your property. And there's a series of rules that apply depending on who your survivors are.
So there's a formula. The government has a formula for people who pass on and don't leave wills. They don't get to take all your money, but they do. Do they administer the estate in your absence then, John?
They don't. I mean, there's...
Because you have an appointed executor. You didn't have a will, remember?
No, fair enough. I mean, there is... the rules just set out, for example, what the spouse gets.
Okay.
If you have a spouse, and one or more children, there's a different set of rules. If you have no spouse and no children, then we start looking at your property reverting to grandparents or descendants of grandparents, and on it goes.
Okay.
They're default rules. If you're comfortable with the default rules, maybe you don't want a will. But I don't think too many people would be comfortable with the default rules. Everybody I know wants to dictate where their property goes after they die.
Absolutely.
I just want to add one point, though, and if you die without a will, there's a provision under WESA as to the appointment of an administrator.
Okay.
So that is
would
where
be similar to an executor.
Well, your closest blood relative is one who has the right to apply.
Okay.
And the public guardian trustee will intervene if there's nobody else who's in the position to apply to be administrator. They will apply, and they will administer the estate when they're like the last resort. But again, it's not necessarily the best choice. I mean, I don't think anybody would choose the public guardian trustee.
Right.
But
it is, as John said, it's a default situation, isn't it?
And in defense of the public guardian trustee, they don't seek this business out. That's their mandate.
Right.
But if anybody would phone their office, they would encourage someone to do a will and to put somebody in charge who gives a damn as to who gets a green teapot. You,
of the two, John Lakes, probably spend more time on a daily basis actually preparing wills for clients, as John White spends more time in court, right? So one of the groups of clients that you encounter a lot, and I even included in the preamble to our conversation this morning, is someone like me. For example, who had that first will done when my daughter was born. I was 30 or 31, and all of a sudden my life changed. And I had to have organization. I have responsibilities. And I had to have a guardian for her, for goodness sake, in case something happened to Carol and me. And so we prepared this big will. And, of course, subsequent to that, I still have a will, of course, but it's not exactly up to date, John. So as we mentioned in the preamble, if you don't have a will, if you've never had a will, perhaps it's time to think about it as part of the repackaging of yourself and your life for the new year. But if you do have a will and perhaps haven't had it attended to for 25 or more years, that update is almost as important as doing it in the first place, isn't it?
It's right, because during that time you're probably listening to your music on tape cassettes or LPs too.
That's true.
And, the problem with an old will, technically it's still a valid will.
Right.
But first of all, the people you name as executors may not even exist anymore. And you may refer to assets, like you may be leaving your cabin on Bowen Island to somebody, and maybe that cabin was sold 25 years ago. So I've seen wills that are 30 years old that are currently completely up to date, and I can see wills that are 4 years old that are totally out of date.
Right.
So if nothing else, you should have a third party look at it and see whether it needs to be updated. I'd say most wills that are 30 years old, particularly if you still have named guardians for children that are now 40,
That are now in their 30 or 40s, exactly right.
Is out of date.
Hardly in need of guardians anymore, and of course they all probably have wills of their own. One of the most important aspects, John White, I think, to a will is this whole business of power of attorney. What is power of attorney, and how does it relate to a will? Does it have to be included in the will, or is it a separate document or appointment entirely?
Well, it's a separate document or appointment entirely. A power of attorney can be used as part of an estate planning exercise, of which the will forms another very important part. But a power of attorney does something completely different. The power of attorney enables the attorney, that is the person appointed in the power of attorney, to exercise a power over the assets and interests of the person who gives the power of attorney. We'll call them the donor.
Okay.
And strictly speaking, although powers of attorney can be limited in scope or limited as to when they take effect, but the general garden variety power of attorney permits the attorney to do almost anything legally that the donor can do.
Okay.
So if the donor gives a power of attorney to an attorney, the attorney can sell their house, can buy a house for them,
Right.
Can do almost anything, except the attorney can't write a will or change a will for the donor.
That's the only exclusion.
Pretty much,
Isn't
other
that
than what's in the
interesting?
face of the document.
Although the power of attorney cannot actually put assets in their own name.
Right.
But the power of attorney could put assets in the power of attorney's wife's name, which is, that's one of the important things when you do power of attorney. You have to appoint somebody who's honest.
Okay, I want to come back to power of attorney in a second, but John Lakes, you talked about the sort of umbrella approach, which is estate planning. Actually, you did, John White. You talked about estate planning, and that includes a will, power of attorney, and what other details? If you're going to sit down, and you do this a lot, you don't just prepare wills for clients. You will if they ask you to, but you look at the big picture and the whole package. So what does an estate plan really entail, John?
Well, for the average person, should be a will, should be a power of attorney. If their assets are quite complex, they may want to consider doing family trusts and corporations, but that's usually more complex. Depending on the circumstances, they may want to do what's called a representation agreement, where it's like a power of attorney, only you appoint someone to deal with healthcare issues.
Oh, okay, all right.
And also you may want to consider doing a simpler document called a healthcare directive, which will deal with more when you're at terminal illness as to the directions.
Right.
Now,
so these are all elements within a well-organized estate plan, John White.
Well, they are. I mean, the purpose of doing an estate plan is to structure your affairs for a time when you're not going to be able to direct what happens to your affairs. The will deals with what happens after you die, when
right.
obviously you can't give direction as to what happens. The power of attorney deals with a situation either where you just want to empower somebody to deal with your affairs generally, or if you're planning for the day when you're no longer capable of
right.
making your own decisions.
Right.
And if you've set it up in
advance,
and
the same with the healthcare directive, same thought pattern behind that too.
The same thought with the healthcare directive or the representation agreement. If you're there but you're no longer capable of making decisions on your own,
right.
you have put into place in advance someone who can make those decisions for you. So you need to choose that person carefully.
Okay, we need to take a quick break here. It's early in the year. Granted, it's only January 3rd, but it is New Year's resolution season. And this is certainly a very doable resolution package. Again, a heck of a lot easier than losing 15 pounds. Not that that's on my agenda at all. But no, really, a whole matter of just that, as John White likes to call it, your legal checkup as you move into the new year. Have a look at what's going on in all of those details in your life, and we'll discuss how they may affect you if they haven't been attended to properly and how to do it right. When we continue with John Lakes and John White from LakesWhyteLLP on Marine Drive in North Vancouver after this.
There's more of the show still ahead. This is The Law Show on CL 650.